Wood-paneled walls lies a truth most Americans never learn. The system routinely enforces judgments that are legally void. And if you don't know how to challenge it, you become its victim. Let's dig in. What is a void judgment? A void judgment is not just legally wrong. It's a judgment issued without legal authority. Null and void ab initio. Definition, Black's Law Dictionary, 4th ed. A void judgment is one which, from its inception, was a complete nullity and without legal effect. How it happens. Court lacked subject matter jurisdiction. Court lacked personal jurisdiction. No proper service, no consent, no verified complaint from an injured party. Court acted in violation of due process. Fraud or misrepresentation tainted the proceeding. Legal case law that destroys void judgments. Penoyer-Redneff, 95 U.S. 7114, 1878. A court without personal jurisdiction over a defendant cannot enter a binding judgment. Ex parte Craig, 282 F 138 41, 1922. A void judgment is not entitled to the respect accorded a valid adjudication. Thompson v. Tom 38 SW 2468. A judgment may be attacked at any time if it is void on its face. Valley v. Northern Fire and Marine Inns Code, 254 348, 1920. Jurisdiction is the power to hear and determine the subject matter in controversy. It is a fundamental requirement. United States v. Throckmorton, 98 U.S. 61. Fraud vitiates the most solemn contracts, documents, and even judgments. 3. How they get away with void judgments. Because most people don't know the difference between voidable, requires appeal, void, never valid, can be challenged anytime. And because the courts are now quasi-commercial entities operating as administrative tribunals, for-profit code enforcers, corporate actors enforcing statutes, not law, they survive on default judgments, unrebutted assumptions, lack of lawful challenges. The system relies on your silence and submission. They treat commercial statutes like criminal law without due process and call it justice. IV. How to enforce and escalate a void judgment claim. 1. Affidavit of truth, judicial notice. Declare lack of jurisdiction, deny consent to commercial venue. Put the burden of proof on the court. 2. Motion to vacate void judgment. File under Rule 60b-4 in federal court. Use similar rules in your state. 3. Notice of fault and default. Send a conditional notice demanding proof of jurisdiction. State their silence equals tacit agreement. Maxims of law. 4. Writ of habeas corpus, if incarcerated under a void order. The supreme lawful remedy for unlawful detention. File in superior or federal court under 28 U.S. Code 2241. Argue the court never had jurisdiction, so detention is false imprisonment. Case, Fay v. Noya, 372 U.S. 391, 1963. Habeas corpus reaches all unlawful detentions, even if under color of state law. V. Escalation tactics. When courts ignore you. 1. File a bar grievance if a judge or prosecutor knowingly enforces a void judgment. 2. File a federal record 1983 civil rights claim for deprivation of rights under color of law. 3. Record your affidavits and defaults with your county clerk or county recorder. 4. Put officials on notice of personal liability. Include maxims of law, bond liability, and your reserved rights under UCC 1308. 5. Submit to the DOJ Civil Rights Division if it rises to systemic abuse. Die. Final words. Know the power of the word void. A void judgment is not a mistake. It's a fraud. It's a lie wrapped in a robe. The Constitution is not suspended in emergencies, nor is jurisdiction created by silence. You are not a legal fiction. You are not a piece of paper. You are not property of the state. And once you understand the difference between color of law and lawful jurisdiction, you'll stop submitting to pretend courts, enforcing pretend judgments. I've got your back with affidavit of truth, motion to vacate void judgment, writ of habeas corpus template, notice of default, absolutely. Let's elevate this lecture to a comprehensive masterclass on void judgments, the invisible weapon of the